And hello, everyone, and welcome to Uncivil Law, where I continue to be on the road, and we also continue to learn through the misfortunes of others. I hope everyone is having a fantastic day, and a day that I thought might never happen ever has finally happened. The Texas Court of Appeals has rendered their decision in the Vic Mignogna case. It's been a hot minute, hasn't it? In some ways, I think that the Vic Mignogna case is maybe one of the first major things to happen to this channel. If you're like looking for benchmarks of the birth of this channel, the Vic Mignogna case would certainly have to be at least one of the milestones, if not perhaps the starting point, depending on when you pick. It's one of the cases, along perhaps with the case also of Katie Joy Paulson with and Toddy Westbrook, that really were at the start of the foundation of the channel, as we now know it and love it. And so this is a case I've been covering, not necessarily since the very beginning. I picked up this case, I believe, just before the decision was made in the trial court. I believe I picked it up sometime when the arguments were being had relating to the motions to dismiss under the Tcpa. But anyways, I've been covering it for a while. I've been covering it since about the time the initial decision was made, maybe a little bit before that, and covering some of the case. And I've done lots of deep dives on this. I reviewed the original complaint. I reviewed the first amended. I reviewed the second amended. I reviewed the response, the Tcpa, the court hearing that was held on the Tcpa motion, and a couple other documents along the way. We've done quite a few videos on this case. And for those of you who are not familiar, let me catch you up to speed, okay? Vic Mignogna is a voiceover artist. He does voices for cartoons, among other things, of course, but that's principally what he's known for. He was working for a long time for a company called Funimation, or he was an independent contractor closely affiliated with. Either way, doesn't really matter. He was perhaps most noted for his voiceover work as the character Broly in Dragon Ball. Okay, and so he has a very popular following. In fact, I was recently at Anime Matsura and had occasion to meet him. I stood in line and shook his hand. Not that he'd remember me, but I thought, since I covered him so much, it was nice to at least say hi. And I'm not sure that he recognized anything I was telling him about who I was or why I was there or why I was shaking his hand. But that is mostly a comment on it being a very, very long day for him, because he had a huge line all day. So my point was not that. My point was more the fact that I was just another voice along the day. So I'm not sure that it was anything memorable for him. But at least thought I made the point of trying to say hi and shake his hand and so forth and so on. But anyways, he has a huge following. People really seem to love him. People really support him. And he was working for this company, independent contractor, doing his Dragon Ball Broly thing. And he was Me Too'd. He was Me Too'd. There were various people who worked with him as part of voiceover artists who said that he did a whole bunch of things. And he did a whole bunch of, very inappropriate things. Now, some of these things I thought were just like stupid that they would even complain about. Like, for example, apparently at one convention, he got a jelly bean, and he said that, and the jelly bean was written with the word Monica on it, which is the name of a voiceover star. Or he said the jelly bean was called Monica, and then he ate the jelly bean, and now he's eaten Monica, which sounds like a joke, but we're taking this super, super seriously. And there were other things too that seemed like, they weren't really that weird or whatever, but okay. But anyway, so he was Me Too'd, and Funimation made some Twitter posts about him. Didn't name him, but were clearly about him, that were saying that we'd done the internal investigation. We found out a whole bunch of things against him. We've done things like that. And so he was fired, and he was blackballed as a result of all this Me Too stuff. Well, he sued. He sued for defamation and intentional infliction of emotional distress. And he lost at the trial court. And this was where I first met Nick Rekieta as well, was through this case. I had covered it a couple times, covered a couple videos on it, and Nick was kind enough to have me on his channel as a guest, and he couldn't have been nicer to me. I expressed my opinions as politely as I could, tried to show where I disagreed, and Nick Ricciuto was very, very kind to me, and we had a very, very cordial discussion about the whole thing. So here's what happened, at least in my view. Okay, so the trial court dismissed it, and it went up to the Court of Appeals, which has now been like 2 years. It's been a hot minute. Okay, and so now this, and the trial court, of course, like was getting started like 3 years ago, 4 years ago. So it's been a hot minute that this whole thing has been happening. Okay, so here's what I think. Okay, and I haven't read the Court of Appeals decision. I want to share that moment with you. I haven't read what they had to say. I heard that he lost, but I haven't read anything, so I don't know what happened really. But I'll tell you what I think happened, and this has been documented in previous videos as well. My view is that the original petition, the original complaint, Vic's original complaint, and the first amended complaint were not legally sufficient to move forward. That was my view. My view was that the original complaint and the first amended complaint were not legally sufficient to go forward. It did not raise enough issues or provide enough details to get past the TCPA standard. Okay, Ty Beard, who is Vic Mignogna's lawyer, filed the second amended, relatively short, prior to the date of the TCPA oral hearing. So there had been a scheduled hearing on whether or not to dismiss this for the TCPA. So there's a hearing scheduled. At the time the hearing is scheduled, the first amended is the operative petition. And it was about, I'm going to get this slightly wrong, but it was like either 10 days or it was a week before, it was something in that time frame that Ty Beard attempted to file a second amended petition. Okay? Tried to file a second amended petition. Now, this second amended petition, if it were operative, would be legally sufficient to pass the TCPA threshold, right? So then one of the things this case came to be about, at least as far as I could conceive it, was whether or not the second amended was operative or not, right? Ty Beard attempted to file the second amended like a week before the hearing, 10 days before this hearing, whatever it was. It appeared, because the record was a little murky, the judge's ruling was a little murky, but it appeared that the trial judge denied entry of the second amended petition, and it appeared that the judge made his decision based on the first amended petition. And if that was correct, then it's correct, right? So the judge has to make the decision about whether or not the second amended petition is entered or not, right? If it should not be entered, and if the first amended is still the operative petition, then yeah, Vic loses. That's my view. If the second amended should be the operative petition, then Vic should be able to move forward. So it became, at least in my view, the legal issue became whether or not the judge should have or was required to enter that second amended petition. And I said, and after doing all this sort of case law on it and doing all the analysis on it and trying to look at it, I came up with the following view. I came up with the view that the judge, although the decision was a little murky, it appeared to be the trial judge denied entry of the second amended as untimely. And it appeared unlikely that that decision was going to be reversed. In fact, I gave very precise odds about what I thought was going to be happening at the Court of Appeals level. So we'll see how I did, all right? So I had 3 different possibilities, all right? I said there was a 91% chance at the Court of Appeals level that Vic Mignogna was just going to lose flat out, okay? There was a 91% chance the Court of Appeals was going to say that the second amended was not the operative petition. The first amended was the operative. The second amendment was not operative. The decision was sufficiently clear from the trial judge. That decision was in keeping with the rules and not an abuse of discretion nor clear error. And the trial judge gets the ability to manage their courtroom. And so that decision, although the Court of Appeals might disagree with it, I thought there was a 91% chance they're going to say the second amended is out, the first amended is in. That was a decision that was either compelled by the rules or more likely permissible by the rules. The trial judge was sufficiently clear in his determination on the record that that's what they were doing. We apply an abuse of discretion analysis. We don't find abuse of discretion. Therefore, the first amended is the correct petition. Therefore, the decision is correct. So I thought there was a 91%, 91% we were going to get some version of that. Then I thought there was a 7% chance that Vic would win in a way that wouldn't matter. Namely, that the Court of Appeals would say, okay, look, it's just not sufficiently clear on the record what exactly happened, because this is where the thing gets a little bit murky on what the trial judge actually was doing, right? It was a little bit, the language was a little bit unclear. It could have been a little bit clearer. So I was like, okay, there's a 7% chance Vic is going to win in a way that's not going to matter. The Court of Appeals is going to say, all right, look, it's just not it's not 100% clear on the record what we're doing, but let's send it back, let the trial court clean it up. And the trial court would inevitably, of course, clean it up in a way that would, deny entry of the Second Amendment, and then we're back off to appeal. And I thought this was an unlikely outcome because it's like, why waste the time, right? If the Court of Appeals already knows that, that the trial judge is going to do that, because that seems like what the trial judge is doing, why waste the time of sending things formally back so he can clean it up? So we're just back to appeal and doing this all over again, right? So, but I thought, there's a 7% chance the Court of Appeals would do that. And then I thought there was a 2% chance that Vic Mignogna would win in a way that would matter. That the Court of Appeals would say, no, this was against the rules. This is against the law. You had to enter the Second Amended. It's a clear error, abuse of discretion. You should have done that. You didn't do that. Go back, treat the Second Amendment as operative, and redo your analysis accordingly. So that was what I thought. 91% chance he'd lose flat out, 7% chance he'd win in a way that really doesn't matter, and 2% chance he'd win in a way that matters. That was sort of where I cast the percentages on everything. All right, so let's go ahead and get started by actually going through this. And this is going to be a first read for me, because again, I wanted to share it with you so that we could share this moment together. And let's just go ahead and get started with this. So this is from the Second Appellate District of Texas at Fort Worth, Vic Mignogna versus Funimation, Jamie Marchi, Monica Rial, and Ronald Toy. All right, let's go ahead and do that. All right, fine. And I'm sure that they will give us a little bit back more of the history as well in terms of what happened. All right. Do I want to read the introduction? How long is the introduction? Let's just skip to the background. We can skip the sort of introduction because it will spoil things for us. All right, so here's a factual background. For more than a decade, Mignogna, Rial, and Marchi worked as anime voice actors for Funimation and appeared together at fan conventions. During that time, various rumors about Mignogna's behavior had circulated to the point that he had a rumors panel in a 2010 fan convention to try to dispel them. More rumors resurfaced on January the 16th, 2019. The same day Funimation's major anime film, starring Mignogna's voice in the lead, debuted. That day, someone with the Twitter handle @Helenia tweeted, "Hey Funimation, why do you employ a known P word?" with a link to an allegation of misconduct by Mignogna at an anime convention. Another person with the Twitter handle @ActuallyAmelia tweeted, "How is Vic Mignogna still working in anime? Every time assault and fandom comes up in a conversation, no matter who I talk to, so does his name. Every time. At some point, an open secret becomes common knowledge, and inaction becomes excusable." Mignogna did not sue @Helena or @ActuallyAmelia or any other online magazines covering the allegations, Polygon, Anime News Networks, and Gizmodo, for defamation. Instead, after meeting online with his fan club and encouraging them to speak positively of his experience with them, Mignogna posted a tweet on January 20th, issuing what he characterized as a generic apology for unintentionally offending anyone. Funimation and its parent company, began an investigation and terminated Mignogna's contract on January 29th. Funimation commented about Mignogna's termination in a tweet on February the 11th. Yeah, they sure did. During the Mignogna-related social media maelstrom between January and February, Rial, Marchi, and Rial's fiancée, Toye, published some tweets, as did Mignogna, whose fans paid into a GoFundMe account. Vic kicks back, set up by our hero and yours, Nick Rikita, on February the 17th to cover Mignona's litigation expenses. Mignogna sued Funimation, Real Toei, and Marchi in April 2019. Nick gets a shout out in the opinion. I'm not sure why, but he does. Okay. All right, procedural complaints. We begin with the procedural complaints because they're dispositive. Yeah, I mean that's whether the Second Amended is operative is the ball of wax as far as I can tell. Okay. A trial court abuses its discretion if it acts without reference to guiding rules or principles. That is it acts arbitrarily or unreasonably. A court's failure to analyze or apply the law correctly is an abuse of discretion. The abuse of discretion standard governs amended petitions. In contrast, a trial court generally has a ministerial duty to enforce a Rule 11 agreement once it exercises its discretion to determine the agreement's validity. Where there's a Rule 11 agreement that's not subject to any exceptions such as fraud or mistake, the trial court has a ministerial duty that is an automatic duty to enforce its terms. Okay. I'm sorry it keeps skipping down like that. I wish it wouldn't do that. I'm having problems with my mouse because I'm on the local. We'll keep making do. In his sixth point, Mignogna argues the trial court erred by not considering his second amended petition and its attachments in deciding whether he met his burden to defeat the motions. This is where the rubber meets the road. Is the second amended operative or not? And I mean, I give myself some credit in highlighting the issue, right? Because I said this is the issue. As I said it many times in videos before. You can go look them up, and I said it in lead up to this without reading it, right? I'm like, yeah, it's the sixth issue Mignogna raised, but it's the operative issue. I said it was the operative issue. Is the second amended operative? That's the issue. Like, if you get past that, Mignogna's fine. If you don't get past that, you've got a real problem. All right. Funimation filed its TCPA motion on July the 1st of 2019. Real Toei and Marchi filed their TCPA motions on July the 19th. Their motions were originally set for a hearing on August the 8th, but the parties agreed to move the hearing to September 6th to allow Mignogna more time to respond. On August the 6th, the parties signed a Rule 11 agreement wherein they agreed that Mignogna would file his response to the TCPA motions by August the 30th. Excuse me. According to the subsequently filed plaintiff's motion for leave to file late response to defendant's TCPA motions to dismiss due to technical issues, Mignogna's counsels unsuccessfully attempted to file TCPA response just after midnight on Saturday, August the 31st. He successfully served the counsel, however, who asked him to provide a certified copy of all notary book pages for notarizations performed by him on August the 30th, the date of the affidavits of Mignogna, Chuck Huber, and Christopher Slosh, which were attached to the TCPA response, were signed with Mignogna's counsel's notary stamp. At 9:04 a.m. on September 2nd, Real and Toei's counsel asked Mignogna's counsel for explanation of how Mignogna, Huber, and Slosh could have signed their affidavits in his presence when none of them were in Tyler with him on August 30th. Mignogna's counsel successfully filed the TCPA response at midnight on September 3rd, the day after Labor Day, along with a motion for leave to file the late response due to technical issues. In addition to 3 affidavits described above, Mignogna's counsel attached to the TCPA motion the depositions of Mignogna, Real, and Toei, along with 342 tweets that were attached as exhibits to Toei's deposition, the unsworn declaration of EM, a convention representative who wrote the declaration in response to statements about her by the CEO of Kawaii Con Convention, whose affidavit was attached to the TCPA motion, and an affidavit by Stan Dahlin regarding his recollection, none, of an incident involving Mignogna that Real had described having occurred on November 2007 Izumuni Con, a total of 8 exhibits. When Mignogna's counsel filed TCPA response at midnight on September the 3rd, he simultaneously filed a second amended petition containing 20 new paragraphs of factual allegations. To the second amended, he attached 17 exhibits, which he described as prima facie evidence sufficient to prove each element of each claim, and referenced the exhibits in 18 of the petition's paragraphs. 9 of 17 exhibits contained evidence that was not attached to the TCPA response. The remaining 8 exhibits consisted of 3 unsworn declarations, 3 depositions, unsworn declaration, and Dali exhibits. 45 minutes after filing the TCPA response in the second amended, Mignogna's counsel replied to opposing counsel's September 2nd affidavit inquiry, stating he would withdraw the 3 affidavits and they had been mistakenly submitted with defects in forms. He noticed withdrawal of affidavits around a half hour later. At the TCPA hearing on September 6th, Mignogna's counsel stated that he had filed the second amended petition after opposing counsel notified him of the defective affidavits. So right away, you can kind of see some of the problems that are going on here, right? We have a lot of issues on the time that things are happening. Things are trying to be happening like right up to the moment this TCPA hearing is happening. We are trying to do stuff that involves trying to amend the TCPA hearing with the second amended, like right up into the last possible minute. And that's just not fair. It goes against fundamental fairness issues and rules. So there's a lot of problems there. So, I don't know why they were trying to do everything at the last minute. Maybe they were trying to be too clever by trying to get them, to do things like at the last possible minute. But it was a real problem. Like if they had filed this stuff as part of the first amended, they would have been in a much better position. But for whatever reason, they didn't. So things are happening like at the last possible minute. And I think that's the reason the court is denying entry. Basically, it goes against principles of fundamental fairness. 45 minutes after filing a TCPA response in the second amended, Mignogna's counsel replied to the opposing counsel's September 2nd affidavit inquiry, stating that he would... Okay, we read that part. Appellates objected to Mignogna's late filing of the TCPA response, to filing of his second amended petition, and to attempted late submission of evidence, citing surprise and their mutually agreed August the 30th deadline. Yeah. Funimation also agreed under the rule of civil procedure Mignogna could not attempt to meet his evidentiary burden by attaching evidence to his second amended petition. Yeah. In ruling on the TCPA motion, the trial court granted Mignogna's motion to late file a TCPA response and deemed it timely filed, but stated that because Mignogna had withdrawn the 3 affidavits, it did not consider them, or any evidence attached to the second amended petition. Mignogna's remaining TCP evidence consisted of the depositions, declaration, and a different affidavit. So he withdrew them in any event, so they're not there. The record reflects that Mignogna essentially tried to use an amended pleading as a late TCPA response to remedy his lack of evidence and thereby avoid the parties' Rule 11 deadline. Yeah, so this is like the problem, right? They had agreed on a deadline for certain things to happen, and now Vic Mignogna is trying to come in after the deadline. And he's like, well, I want to file my TCPA response. And as part of his TCPA response, he's trying to file a second amendment. And that's not in keeping. So he's late under their agreement, among other problems. So he's trying to circumvent their previous agreement, and that's not going to work. The trial court had a ministerial duty to enforce a valid Rule 11 agreement, and Mignogna did not argue in trial court or in this appeal the parties' Rule 11 agreement setting a deadline for TCPA response, and therefore evidence was invalid. Yeah. Accordingly, we hold the trial court did not abuse discretion by refusing to consider Mignogna's second amended petition and attachments found in violation of Rule 11. I mean, yeah. Citing Easy Pawn for the proposition that where affidavits are filed late in violation of a Rule 11 agreement on deadline, and the opposing party seeks enforcement of the agreement in the trial court, neither the trial court nor the Court of Appeals can consider the affidavits. Because the trial court did not abuse its discretion by excluding Mignogna's second amended petition as being violated of the agreement, we need not address the remaining violations. And that's basically the ball game, right? That's basically the ball game. They had an agreement. And the court is giving effect to the agreement. And Mignogna's counsel is trying to play cute to get around it. It's like, well, everything has to be in by this date, and he's filing a second amended, not as a TCPA response, but in order to bring in new evidence, new information, and it's too late for that. It's just too late. The timing is just off, and also it was just before the hearing. So even in the absence of an agreement, the trial court probably would have excluded it too. They were trying to say that the rules require the court to enter the second amended, which didn't make any sense because you don't get to just amend for the hell of it forever. You get one amended usually for free, and then you have to ask for permission beyond that anyway. So you're not entitled to a second amended. That's by discretion. So the trial court could have just excluded it for that reason, because it's too late. It's too late because it's in the second amended. The trial court's discretion is just too late in time. It violates the agreement. There was a reason I thought that Vic Mignogna was going to lose, flat out. It's the timing just completely doesn't work. In his seventh point, Mignogna enrobes his TCPA sufficiency complaint about the appellee's motion. Within his argument, the trial court should not obstruct Funimation and Rial's and Toye's evidence. Excuse me. However, he ignores that in her TCPA motion, Marchi incorporated and adopted by reference all evidence attached by Funimation and by Rial and Toye to their respective TCPA motions to prove Mignogna's status as a public figure. He's a pretty public figure, I think. And that their representative statements were made as a matter of public concern. That part's debatable, but he's a public figure, so it doesn't matter. Mignogna did not object to Marchi's evidence or to her incorporation and adoption of the other party's evidence, and he does not complain about Marchi's evidence on appeal. Because Marchi's evidence and Mignogna's own evidence generally established his public figure status and matters of public concern, the error, if any, was harmless. Yeah, I mean, I think he's a public figure. His lines for his meet and greets at Anime Matsuri tend to suggest that he's a public figure. He is the lead voice actor for a major part and has gone out of his way to inject himself in panels and all the rest of it. So he's, I think he's pretty much a public figure. That's fine. We overruled Mignogna's seventh point without reaching the merits of the evidentiary arguments. Yeah, because it's harmless error. It doesn't matter either way. That's true. Because Mignogna raises no other challenges to whether appellees met their initial TCPA burden, we consider that burden established for our analysis. Okay. In his first, second, third, fourth, and fifth points, Mignogna argues he met his burden to establish his prima facie case for each essential element of each of his claims. We reviewed de novo a ruling on the TCPA motion because you have to, that makes sense, because you have to decide it as based on the pleadings, but I found them to be deficient, and I'm sure this Court of Appeals will too. In our review, we consider the pleadings and supporting and opposing affidavits stating facts on which liability is based. Regarding the non-movement's burdens to establish clear and specific evidence for a prima facie case for each essential element of his claims, prima facie case is given traditional legal meaning, which is evidence sufficient as a matter of law to establish a given fact, if not rebutted or contradicted. It is the minimum quantum of evidence necessary to support a rational inference the allegation to be true. Yeah, we didn't have that for tortious interference on the original pleadings, I didn't think. Clear and specific evidence is not defined by the TCPA or by common law, but our sister courts have aptly summarized it as follows. Proof by clear and specific evidence is not simply fair notice of a claim. Rather, under clear and specific evidence standard, A plaintiff must prove enough detail to show the factual basis for the plaintiff's claim. This is not an elevated standard, nor does it categorically reject circumstantial evidence. It does not impose a higher burden of proof than required of the plaintiff at trial. Yeah, so just the lack of detail was a problem in the original complaint. There was definitely a lack of detail issue, to be sure. All right. Let's read some more. Conclusory statements and speculative evidence, however, will not support the burden. Yes, conclusory statements don't work. Speculation doesn't work. The Tcpa does not forbid using circumstantial evidence or rational inferences to establish a prima facie case, but an inference is not reasonable if it is premised on mere suspicion or susceptible to multiple equally probable inferences, requiring the fact finder to guess to reach a conclusion. Yeah, that sounds about right. All right, the elements of defamation are defamation. We don't need to read that. A defamatory statement must proximately cause damages unless the statement is defamatory per se. A statement is defamatory per se if it accuses someone of a crime or foul of loathsome disease or of engaging in misconduct. Whether a statement is defamatory per se is generally a legal question. Statements of opinion about a public figure on matters of public concern are not actionable as defamation because they cannot be proved false. Calling someone a sexual predator falls within the broader principle that a speaker's individual judgment that rests solely in the eye of a beholder is mere opinion. Noting another court's explanation that unlike convicted felon, which has an objectively verifiable meaning, sexual predator is a loose, figurative, or hyperbolic language that's immunized. So without more, it basically becomes the same idea as calling someone a racist, according to the relevant case law. So it's calling someone a sexual predator by itself in a flat statement without more is not actionable. Okay. I'm not sure I necessarily agree with that, but that is the law. I understand. Furthermore, for a public figure plaintiff, an essential element of defamation claim is that the defendant published the alleged falsehood with actual malice. In this context, actual malice means knowledge of, reckless disregard for falsity of the statement. Mitova says, can we call people sexual predator without any merit now? At least in Texas, in a completely flat statement that doesn't add any other descriptors, yes. It would be a pure matter of opinion in that specific hypothetical. The mere failure to investigate the facts by itself is no evidence of actual malice. Okay, that's helpful, Dark Logic. Thank you for your contribution. Likewise, the mere fact that defamation defendant knows the public figure had denied harmful allegations or offered an alternative explanation of events is not evidence defendant doubted the allegations. Proof of reckless disregard requires evidence defendant had serious doubts about publication's truth. For a TCP non-movement to make a prima facie showing of the elements of defamation, the parties' pleadings and the evidence must establish the facts of when, where, and what was said, defamatory nature of the statements, and how they damage the plaintiff. This is because defamatory claims context matters. This is very true. Here's a case stating that without proving the context of alleged defamatory statements, the plaintiff was abusive, there was no basis for a trial court to conclude the statements were defamatory per se. Context does matter. In construing a statement to determine whether it was defamatory, we view it as a whole in light of surrounding circumstances, based on how a person of ordinary intelligence would perceive it. The reasonable man test, as always, pops up again. The reasonable, ordinary, common, normal man, normal, ordinary prudence. Right. Okay. Dark Logic, I don't mind you expressing your opinion. I just wish you had expressed it with a bit more tact. Was all. Um, I, for example, said that I didn't necessarily agree with it, but I understood it. That's just me. Mignogna argues that Marchi defamed him through her statement that he had assaulted her by grabbing her hair, yanking her head back, and whispering something sexual in her ear. In his first amended petition, he alleges that on February the 8th of 2019, Marchi retweeted that he had assaulted her several years prior by grabbing her hair and whispering in her ear what he whispered she couldn't remember, that in the last week or so, I've heard accounts of him doing the exact same thing to half a dozen other women I personally know, and that Mignogna is a predator. Marchi's entire tweet stated the following, quote, I stand with victims. My experience is minor in comparison to many others. However, realizing this was an isolated incident, I feel compelled to share. Several years ago, I was in the lobby of my job when I was approached by a coworker. This guy gave me the creeps already. He gave it to almost all the women in my job. But I almost feel like he had to be nice to him anyway because of how revered he is within the industry. As we said hello, he stood to the side of me and started running his fingers through my hair. Now, I do work in an affectionate industry. We hug a lot, and on occasion we kiss each other on the cheek. But even for an affectionate environment, this felt off. I didn't say anything to him about it, though. It was just his fingers in my hair. I didn't think it was that big of a deal. At that point, he splayed his fingers, put his hands at the base of my skull, and made a fist. When he did this, he grabbed my hair close to the root, effectively preventing me from moving my head at all. He then jerked his fist, yanking my head backwards and toward him, and whispered something in my ear. I don't remember what he said specifically, but I do remember it being sexual in nature. This was not normal. This wasn't just a hug or a kiss on the cheek. I did not like it. I have no memory of getting out of the grass, but I assume what the F are you doing was part of my technique. Afterwards, I was completely and utterly dismissed this experience. I dismissed the way I'd been touched. I dismissed having this man grab me. I dismissed having my head jerked back. I dismissed the inappropriate content. I dismissed the entire encounter. I've never reported this event to the company. It actually didn't even occur to me that I should have. Although if it had occurred to me, I can't say that I would have reported him. This guy was worshipped by his fans. He was worshipped by the studios because of his fans. He was the most popular voice actor on the convention circuit. Everyone treated him with kid gloves because he was the one and only Vic Mignogna. Who was I? A nobody in comparison. I didn't matter and I knew it. Risking being blacklisted for my work in conventions simply wouldn't have been worth it. As I look back on this moment and discuss it with my family and friends, I can see that his actions qualify as simple assault. Would he have gone to jail if I pressed charges? I'm not sure. Almost certainly not. Would people believe me over a man who held Bible studies in hotel lobbies? And if they did, would they care about the truth if it meant tarnishing the reputation of their favorite voice actor? In the last week or so, I've heard accounts of him doing the exact same thing to half a dozen other women I personally know. I am friends with these women, and we never told each other about our experiences. Some dismissed it like me. Others felt too ashamed or scared to say anything. I struggled with the guilt I felt for having been so dismissive of his actions. Had I been able to speak up then, maybe less women would have had to experience what happened to me when they were unable to get out of Mignogna's grasp. I'm speaking up now because I didn't think about this event until I realized other women had experienced the same thing. I thought it was just me, and at first I didn't want to say anything because my experience was not nearly as bad as what other people had suffered at the hands of this man. I wanted their stories to be heard first because they were important ones. But in this moment, I want the others who I know are out there to hear this. It wasn't just you. It's okay if you didn't say anything to him or anyone else. You are not responsible for what happened. You do not have to be dismissed, ashamed, or afraid. Also, I hope if anyone ever goes through a similar experience, they will know from the start their body is not up for debate. Their body is not the property of the most popular person in the room. Their body is not responsible for a company, a show, or an art form. That might be depending on what they do for a living. Their body is most definitely not responsible for the reputation and livelihood of a predator. Very exciting. In unsworn declarations, Marchi stated that she decided to publicly state the truth about what Mignogna did to her in early 2019, after other women began coming out with the truth about their various experiences with him, and that she did so that other women who were victims of Mignogna or other aggressors would know that they are not alone, and to show solidarity with and empathy for those victims. Marchi further declared she had told the truth and that she had been harassed, threatened, and lambasted by Mignogna's supporters and his legal team, even though she had not made these statements out of malice or any desire to hurt. And despite her own hurt and anger, Marchi said, "My intent in the outcry was always to provide an opportunity for healing and encouragement for bravery for both myself and other victims." In her deposition, Mignogna admitted to the incident involving Marchi's hair, but stated it was not painful, it was not hurtful, it was not sexual, and it happened at least 4 or 5 years ago, maybe longer. And denied ever whispering anything sexual in her ear or having any sexual interest in her. Mignogna testified that Marchi had defamed him by publicly posting and mischaracterizing a very casual, brief interaction in public in the lobby of Funimation, and that to his recollection, it was a very casual, playful interaction, as happens all the times in the hallways of Funimation. However, he agreed that Marchi could perceive the incident differently, and there's kind of the end of the ball game, right? The underlying incident happened. Her perceptions of it are her opinion. So that's kind of the end of the ball game, and sort of the defamation of that aspect of it. I thought it was playful, fun, carefree. She didn't. We both agree on the facts of what happened. We disagree on our perceptions. That's a difference of opinion. He didn't recall if he said anything in her ear, but he said, "If I did, it was literally something like, 'Ooh, I love your hair,' or 'I love it, it's awesome.'" He also agreed that Marchi was not the only woman whose hair he pulled, and when asked if he had any evidence that Marchi did not believe the statements were true when she wrote them, he replied, "I can't answer for her. I don't know what's in her mind. I can't say whether she believes it or whether she's joining in the pile on. I don't know." Mignogna's TCP evidence did not show Marchi had published a false statement of fact. Yeah, her Twitter post, to the extent it presents facts, are true. This incident happened. He grabbed her hair. Everything else is kind of opinion. So there's no defamation. Accordingly, the trial court did not err on denying it. Yeah, they basically agree to the fundamental facts. And everything else is opinion, so no defamation. Yep. In his first amended petition, Mignogna alleges that Rial had made the following statements or taken the following actions to defame him. On January the 16th of 2019, Rial liked and retweeted a tweet by Helena that accused Mignogna of being a homophobic, rude asshole who had been creepy and underage female friends for over 10 years. I mean, that's a lot of opinion, to be quite frank. On January 17, 2019, Rial liked and retweeted 2 tweets from Marzi Girl that accused Mignogna of great volumes of sexual misconduct, that encouraged Funimation to reconsider hiring Vic Mignogna as a voice actor in the future, and that initiated the hashtag #KickVic. Oh, wow. On February the 16th of 2019, Rial tweeted, "It happened to me, and that she was only one voice on a sea of many. He's hurt enough people, he's a sick man and needs help." On February the 11th, 2019 thread, under Funimation tweets, Rial tweeted, "There were multiple investigations with testimony, proof, evidence. Companies don't cut ties without the things." Well, sometimes they do. However, that information is classified. "I'm one of a dozen of men and women who participate. Stop harassing me." She also tweeted, and just so we're clear, he's the legal definition of harassment. Harassment is governed by state laws, but it's generally defined as a course of conduct which annoys, threatens, intimidates, alarms, or puts a person in fear of their safety. Which, as a sort of back of the envelope definition of harassment, I've seen worse. On February the 19th of 2019, in a tweet, Rial accused Mignogna of sexual harassment, of kissing her without consent, and treating others similarly at conventions. Reference having spoken with investigators to corroborate the testimony of others, telling stories similar to hers, and spoke of Funimation's investigations. She stated, the investigations were incredibly thorough. Each person was interviewed, the evidence was weighed, and a decision was made. Each company has to look out for the safety of their employees. In this instance, these companies felt they had made the best decision to protect their employees and contract workers. Also, these companies weren't obligated to share any information with you. Many of the women who came forward have chosen to remain anonymous, especially after seeing the way I was attacked. Please respect their privacy. Whoa. Mignogna argues he specifically denied Rial's accusations against him, but to support his assertion, he primarily references his affidavit and Slosh's affidavit, both of which he withdrew before the hearing. His unsworn declaration, Slosh's unsworn declaration, neither of which were before the trial court considered because they were attached to the second amended. So her facts are unrebutted on the record. Further, despite having attached Rial's entire deposition to his TCPA response, Mignogna provided no evidence of her state of mind with regard to the actual malice evidence. To the contrary, and as at least one of complainant statements, Rial testified in her deposition that her February the 11th, 2019 tweet, which stated, and just so we're clear, he's the legal definition of harassment. Harassment is governed by state laws, but generally defined as a course of conduct which annoys, threatens, intimidates, alarms, or put a person in fear of their safety, contains a typo. Rial testified that she had intended to say, here's the legal definition of harassment. She stated that she had copied and pasted the definition of harassment she found on the internet into the post. Mignogna provided no evidence to refute the characterization of her statement, and likewise failed to meet his burden to show a prima facie case of each element of defamation, particularly falsity and actual malice, as to Rial and his TCPA response. So basically, he loses it because he never fought it. He loses it because he never fought it, and he never fought it because he only fought it in his deposition, which was attached to the second amended, which he himself withdrew, and would have been thrown out in any case. So her statements are unrebutted. So yeah, that would be a problem legally. Yep. Fundamation. Affidavit, not deposition. Thank you for the correction. Mignogna argues that Fundamation defamed him by publishing two statements about that, when viewed together, conveyed a false and defamatory meaning. In his first amended, Mignogna alleged that Fundamation defamed him when he published the following tweet on February the 11th of 2019. Everyone, we want to give you an update on the Vic Mignogna situation. Following an investigation, Fundamation recast Vic Mignogna in Morose Monocanon Season 2. Fundamation will not be engaging in Mignogna in future productions, and we do not condone any kind of harassment or threatening behavior being directed at anyone. As with other defendants, Mignogna provided no evidence to meet his actual malice standard. Accordingly, they did not err by granting Fundamation's motion to dismiss. He would have a tough time doing that for Fundamation. He would never be able to get to Fundamation. I mean, as much as we'd like to. I mean, Fundamation's investigation may not have been everything we want to be, but to show that their statements were made with the actual malice requirement, it would be really tough. Like, they did do an investigation, and they could have done more, and maybe should have done more. But to say they engaged in actual malice, I mean, with a public figure, I mean, they could have simply. They didn't really need to rely. They didn't need to do an investigation. They could have simply relied on Rial statements, for example, because that would have been reasonable. And you can't show actual malice. You can't show reckless disregard. If Rial appears to be superficially credible. So I think, yeah, getting to Funimation, you're always going to have a tough time getting to Funimation. In the first amended petition, Mignogna alleges that Toei made the following statements or took the following actions. On January the 16th, 2019, Toei tweeted that Mignogna was a predator. On January the 31st of 2019, Toei tweeted that he knew of at least 4 assaults by Mignogna and was glad to see conventions canceled. On February the 1st of 2019, Toei tweeted he knew Mignogna was guilty of at least 4 accounts. On February the 2nd, Toei tweeted Mignogna needed to prove himself not to be a predator, and that Mignogna is a predator based on Toei's insider knowledge about Sony's investigation. On February the 4th of 2019, Toei tweeted multiple times that Mignogna was a predator, called him a perp, and posted, "He's down because he took advantage of girls, buddy. How about get a grip on reality and stop harassing people? Over 100 accounts and still more to come, and you defend this sack of shit. Get a life." On February the 5th, Toei tweeted the accusation that Mignogna was a predator. On February the 6th of 2019, Toei tweeted that over 100 women had made accusations of assault against Mignogna that were corroborated, that there were mounds of testimony, and Funimation had proof. That's why they fired him. On February the 13th, 2019, Toei tweeted evidence. He's been fired, there was an investigation, and these actions have corroborated testimony. On February the 16th, 2019, Toei tweeted, "Let's see who walks away as a registered sex offender." He won't. But, that's speculative. That's fine. On February the 18th of 2019, Toei tweeted their Funimation's decision was on things that happened to Funimation employees. On February the 21st of 2019, in a tweet, Toei accused Mignogna of assaulting Rial. On February the 23rd of 2019, in a tweet, Toei accused Mignogna. Thank you, by the way, for your super chat. I believe it's the first super chat of the night. Dark Logic says $10. As much as I hate this crap surrounding the Vic case, once again, thank you, Uncivil. You try your best to be neutral and keep things by the law. Appreciate your content. Keep it up. Thank you. I mean, that's what I aim for. I aim to be a legal education channel. And I really appreciate that, right? I do not, I just simply try to give good legal opinions. And the Court of Appeals is, in my view, giving good legal analysis. This tracks much of my own legal analysis, to be sure, because, I looked at the relevant law and seemed to be right. And, Vic Mignogna might have been able to win his case if he had pled it differently. But, there were mistakes made, and in my view, there were mistakes made, and those mistakes were devastating. And that's the law. When you're playing the game, you've got to play the game, just like any game. You go into the pitch and you can start playing. But yeah, I appreciate the compliment. That's kind. On February the 21st of 2019, a tweet, Toei accused Mignogna of assaulting Rial. On February 23rd in 2019, a tweet, Toei accused Mignogna of cheating on his fiancée, assaulting ladies and robbing fans, and assaulting more and more people than Rial. Not so sure about this orange background. Let's try purple. Mango? Purple. Purple's a little softer on the eyes. Let's try purple. On April the 7th of 2019, in a tweet, Toei accused Mignogna of forcing himself on people in a sexual manner without consent, and that results in assaults. Mignogna also alleged that Toei had tweeted more than 80 times that Mignogna had sexually assaulted or assaulted Rial, more than 10 times that Mignogna had sexually assaulted or assaulted 3 of Toei's very close friends, more than 10 times that Mignogna had been accused of hundreds and possibly thousands of assaults, and at least 17 times that Mignogna is a predator. Mignogna's pleadings and evidence had to establish the facts of when, where, and what was said, defamatory nature of the statements, and how they damaged him. However, Mignogna merely attached 342 purported tweets by Toei without surrounding context, the tweets to which Toei was responding, which is required to determine if the statement is defamatory per se. Further tweets referencing The tweets referring to Mignogna as a sexual predator or variations thereof are a non-actionable opinion, apparently under Texas-specific law. So this again goes to statements like the comparable statements in this domain are comparable statements that are treated similarly are statements like white supremacist or racist, right? The idea is that those are opinions, right? Again, we have to be very careful when expressed flatly, when expressed without additional stuff. You know, the statement by itself, it's like, because what makes someone a racist, what makes someone a white supremacist, right? Is somewhat in the eye of the beholder. It doesn't purport to be a fact, or it doesn't purport facts. So the Texas Supreme Court, and I'm not sure I 100% agree with this decision, but the Texas, I apologize, not Texas Supreme Court, Texas Court of Appeals, at least, has said that sexual predator is, without more, a statement of opinion. Thank you, E, for becoming a member and hitting that beautiful join button. I appreciate it. Blue Internet says the accusation of deviant sexual behavior is defamation per se. Yeah, the Texas Court of Appeals directly contradicts you on this one. That's the kicker. Accusation of sexual behavior is pure opinion without more. And it being a pure opinion, it can't be defamation because it is not a statement of fact, according to the Court of Appeals, as a matter of law. So, that is there. Let's see. As with marching Rial and Funimation, Mignogna also fails to show that Toei had acted with actual malice. Again, if the Second Amended were in play and his deposition, his affidavit were in play, we'd be in a better position. But yeah, the tortious interference claims were even worse on the original pleadings and then the First Amended. Mignogna testified that he averaged attending between 20 and 30 conventions a year, and by the time of his June 22nd, 2019 deposition, he had attended 9, presumably of that year. He further testified it was not unusual to not be invited to a convention he attended the year before, because once the convention has you as a guest, they don't typically bring the same people back every year because the number of the people in the industry. Mignogna added, in fact, I'm actually an exception because I do get invited back often to the same events. So if somebody doesn't invite me back, there's nothing really unusual about that. So that's the problem, right? This is the problem, right? In order to show tortious interference, he has to show interference. And he says, okay, look, he says it's trade practice, and he would know. He says it's trade practice to not be invited back to the same convention the subsequent year. Now, he says it does happen. So it's not like unheard of, and particularly for him, but again, it's like it's not expected. It's not expected. So if he's not being invited to a whole bunch of conventions that year, right, the question is why? And he's having a problem with tortious interference because he's having a problem showing the interference, because he's having a problem showing he would have been invited. He's having a problem showing the expectation on those kinds of things. He stated the number of conventions fluctuates from year to year, and while some involve written agreements, others would be based on oral invitations. Mignogna agreed that he did not go back to MetroCon Tampa 2018, and he was not invited back in 2019, that he had not been back to Anime Central since 2016 or 2017. And although he was at ToshiCon in 2018, he was not invited back in 2019. Mignogna then repeated, as I said, typically, with 70 or 80 voice actors and industry people, writers, directors, artists, they don't typically invite the same people back year after year. Mignogna admitted his deposition. With the exception of one convention, Kamahi-Con, he had no written evidence, emails, text messages, or anything to show appellees had contacted or encouraged conventions not to invite him. Further, Mignogna was able to attend Comic-Con So that's harder on that tortious interference because you were able to go. Although Mignogna testified at deposition prior to 2019, to his knowledge, he had not been banned from a convention or asked not to come back. Rial and Toye's evidence, affidavits by convention officers, showed otherwise. So, yeah, he says, "Oh, I haven't been banned and not asked to come back," but Rial and Toye say, "Yeah, that's not true," with affidavits. Mignogna's primary evidence to show that Rial and Toye had interfered with his Comic-Con contract, the Slotch affidavit, and unsworn declaration were not admitted evidence. There's that stuff being withdrawn again, late filings again. See, this is a problem. This is the problem. The problem is the late filings. The problem is the Second Amendment was too late. The problem is the affidavits were too late. The problem was it was not timely. It's like, if you're stuck with that First Amendment, if you're stuck with that original complaint, and you're stuck with that First Amended on a TCPA standard, as I understand the law, and I said this years ago. It's like, nope. I'd also like to point out, I got all kinds of shit for saying that, by the way. I got all kinds of shit about people saying I didn't understand the law. All kinds of shit about people saying I didn't understand the TCPA. The amount of shit I got on this case rivals the amount of shit I got, for example, on something like Katie Joy Paulson versus Toddy Westbrook, which I was also right about for the same reasons. It's like, yeah, I'm telling people what they don't want to hear, I guess. I'm sorry I have to be the bearer of bad news, but don't shoot the messenger. It's not my fault. I didn't invent the law. I'm just here to tell you what it is and try to interpret it as best as I can. I'm like, yeah, no, that original complaint's not going to work. That First Amendment is not going to work. I think that Second Amendment is too late. I don't think it's timely. I don't think the judge abused his discretion. It's like, I'll get over it. It's Slatosh. I'll try. I'll keep remembering that. In his deposition, Mignogna acknowledged that he did not know of any instances when Funimation pressured a convention not to hire him or not allowed to attend, and he failed to link any specific Funimation statement to any lost business. Appellee's of evidence also showed it would have been nice, like you didn't necessarily have to get it in a formalized affidavit. An email would have been helpful. Like, did you not bring me because of them, interfering? That would have been helpful. Yeah. Appellee's evidence also showed there was substantial negative press arising from claims other individuals made before and around the same time, and after Appellee's made the statements Mignogna complained about, and Mignogna failed to show any convention's decision not to invite him stemmed from the statements rather than routine decisions or as a response to negative press. Again, Mignogna was in a position to get this. He could have potentially gotten it in emails. He could have emailed the convention directors or whomever and said, did you not bring me on because of Monica telling you lies? I mean, you write a more sophisticated version than that, but you could have gotten statements from the people in emails, or you could have gotten statements on the phone that you would have been able to put in your own affidavit. I mean, there's ways to get around this problem, or have an investigator go investigate it and interview them. That might work. But yeah, there's lots of ways to get statements from the convention directors that said the reason we didn't bring you on was because of what they said, rather than some other reason. I mean, the only reason you can sue is because of what they said. So, hire a private investigator or send off some emails or pick up the phone or something. I don't know. But, at least one statement to that effect was in the Second Amendment. Yeah, well, too little, too late, right? On the record before us, Mignogna failed to provide any evidence he had a valid contract or would have had a valid contract but for the interference. Yeah, that is a problem. Yeah, that's a problem. Civil conspiracy. Well, you can't prove any of the underlying acts, so conspiracy's out. Because Mignogna failed to establish defamation or tortious interference claim, the derivative claim of conspiracy is also gone. Yeah, since you can't prove the underlying things, you can't prove a conspiracy for the underlying things, so that's out. Attorney's fees and sanctions. The Tcpa, in effect, at time of litigation, require the trial court to award to the successful movement reasonable attorney's fees. Mignogna challenges the imposition of fees and sanctions, while Royale and Toye challenges the amount. I would imagine that the amount's going to be upheld, but let's see. Okay, yeah, because the eighth point, the sanctions motion is improper because they should have ruled for me. No, they shouldn't have. The trial court made the right decision. In a single cross appeal issue, Royale and Toye complained the final judgment inappropriately awards them the amount of attorney's fees, $100,000 lower than the amount requested, and supported by competent evidence of $282,000. They argued the arbitrary manner in which the trial court awarded attorney's fees, coupled with their uncontroverted evidence, requires us to reverse and render an award of fees because they faced a more complex fact pattern than Marchi or Funimation. I'm not sure about that. And were forced to respond significantly to more attacks by Mignogna. Not sure about that attack either. Rial and Toye pointed out the counsel had to defend two individuals instead of just one, that the only defendants who were deposed and the only ones who answered discovery, as well as the ones who bore the brunt of bad faith litigation. Okay, a reasonable attorney fee is one that's not excessive or extreme, but rather moderate or fair. Reasonableness is a fact question that exists within the court's sound discretion. So that's like, yeah, good luck on overturning that, right? Let's see. A trial court abuses its discretion if it's arbitrary and unreasonable without regard to common principles. The Supreme Court has stated the fact finder's starting point for calculating the attorney's fees is determine reasonable hours multiplied by a reasonable hourly rate, based on the normal factors about how attorney's fees gets calculated. Basically, what's reasonable in the market for those kinds of positions. Principle that the lodestar reflects the necessary amount, blah, 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 blah. A trial court is not, even if a fees claimant's testimony is uncontroverted, a trial court is not obligated to award the requested amount. Attorney fees may be proven as a matter of law, in some cases by uncontroverted expert opinion, if that testimony is readily construed, blah, 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 blah. The amount of reasonable attorney's fees has become a frequent subject of TCPA and appeal since some other case, which is set out above, clarified the evidentiary standards. Our sister circuit has considered the applicant's complaint the trial court erred by not awarding the full amount of fees, costs, and expenses after they had prevailed. The appellants attached detailed billing statements and affidavits of their trial and appellate counsel and their expert on attorney's fees to the memorandum in support of fees, and the appellees had responded with affidavits on attorney's fees from their own experts. The appellate court determined that the appellee's affidavits were conclusory and constitute no evidence to overcome the basic lodestar calculation. Okay. Blah, 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 blah. We recently considered the fees in some other case. In another case, we did some other things. So forth and so on. Continuing on. We now turn to the instant case. Okay. Here in its order awarding attorney's fees, the trial court labeled the amount of fees reasonable and necessary and awarded $48,000 in change to Marchi. The specific amount she had requested and awarded to Funimation, Rial and Toye, $50,000 each, despite their substantially larger requests. The trial court did not explain why to reduce the fees award requested by Rial and Toye or Funimation, and the trial court made no written findings of fact. When the trial court makes no factual findings, we infer all facts to support the decision. Okay. Each of the appellee's lead attorneys testified about their qualifications and work. Mignogna also testified about the case, but presented no evidence to contradict the attorney fee evidence. Okay. The trial court shows unredacted statements, graduated from this school, and so forth. They have a TCPA tactic practice. They've done a lot of these motions. Blah, 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 blah. Liam testified his hourly rate was $5.15. Okay. Double board certified attorney. Ooh. Was hourly rate was $6.50. He's one of the foremost people in terms of arguing Texas anti-SLAPP cases at the Court of Appeals. Maybe I should look to that as a career. Maybe I could be one of the foremost people in Texas arguing anti-SLAPP cases for $650 an hour. That sounds pretty good. Maybe I'll do that. Okay, they testify the fees amount to $271,000, billing records that are attached. Total fees award based on the invoices. Limoni worked 244 hours and multiplied the hour rate times 515, which would have been $125,000. And then there's some other amounts in there. Limoni testified he had not billed his clients for time spent watching YouTube videos posted by Rekieta. I guess that was a freebie. I mean, Nick Rekieta is a fantastic channel, and I guess he's doing that one for free. Who had set up Mignogna's GoFundMe site and whose information about litigation had been leaked. Limoni said he watched the videos because Rekieta would actually say things that we would see showing up in motions and hearings, and because he tells us what plaintiff's legal counsel is thinking. Otherwise, I would not watch him. Aw, that's mean. Nick Rekieta's fun. He stated, I had to suffer through those. Nick Rekieta getting shade. But I didn't bill the client. Only one of us had to suffer through that, and they shouldn't have to pay for that, so I did. Wow. Limoni is not a fan of the Nick Rekieta show. I wonder if he has any feelings about Uncivil Law. Oh man, that's you've been dissed. You've been dissed on the record and mentioned in the Court of Appeals decision, man. Limoni is not a fan of yours. That's harsh. Limoni testified that he requested $15,000 in litigation costs, including Westlaw, witness affidavits around the country, and so forth and so on. Blah 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 blah. And just give me to the bottom line. Watching the attorneys argue over legal fees is like the least important thing. Skip, 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 skip. Does he owe more money or not? By awarding essentially the same amount, the trial court appeared to factor in all the testimony addressing expertise and experience, as well as the distinction between a large firm's billing rate and a small firm's billing rate, and the fact that March's counsel had leveraged the heavy lifting by Rial and Toy's legal team to prevail with significantly fewer hours at a significantly lower cost. Rial and Toy's legal team, although it had more expertise in the subject matter, also had higher billing rates and more people, which they used to address the novel issues raised in this complex case that were not reached on appeal because Mignogna failed to preserve or brief those issues. Yeah, that too. On the record before it, the trial court had ample evidence upon which to exercise discretion. How the trial court's comment makes it apparent what the record otherwise shows, despite the base low-star presumption of reasonableness, and Rial and Toy's evidence, which was not controverted by Mignogna, the trial court abused discretion when it awarded Rial and Toy collectively just over one-third of the requested amount. Although the trial court was not obligated to award any specific amounts requested by the attorneys, and discretion to reduce the amount of attorneys' fees, the trial court abused discretion by assessing such a significant reduction in light of, among other things, March's counsel testimony that he made use of the additional work and heavy lifting of the case. Contrary to the trial court's comments about car repair bills, legal services are not fungible. Okay, it's nice to know. It's nice to know that lawyers are not fungible. That's nice to know. Nor was the Mignogna case against each defendant exactly alike, and a trial court should have properly characterized each base lodestar with that in mind. Accordingly, we sustain Rial and Troyer's cross issue and remand this portion of the case for a reasonable determination. So it looks like Mignogna is going to have to pay some more fees. It looks like Mignogna is going to have to cough up some more money for attorney's fees. So, yeah, that's the end of that. So, yeah, basically went the way I thought it would. I didn't really have a strong opinion on the attorney's fees issue because, like, I didn't really have a strong opinion, but, yeah. So, that's it, man. That's it. So, on the whole, I agree with the trial court. On the whole, I agree with the trial court. And I agree with the Court of Appeals. We can't play Jackbox right now. I'm not set up for that. But maybe in the future. Well, I suppose I could download it while we're talking. Do we want to play Jackbox? Let me contemplate whether or not we want to play Jackbox while I'm talking to you guys. But yeah. Anyways, no, I basically agree with the Court of Appeals analysis. I agree that neither the original nor first amended was sufficient. I agree the Second Amendment would have been sufficient, and I agree that it was too late in time. I didn't really analyze it under the Rule 11 agreement. But fine, that works too. But also just like it was way too late, and it was a violation of fundamental fairness. It was the Second Amended. It's not a matter of right. It's coming kind of to surprise the parties. It's in violation of fundamental fairness to strike it for violation of fundamental fairness. It's like we're here to decide the TCPA about whether or not we're here to decide. The problem is, right, the TCPA is a motion to dismiss, right? We've already scheduled this hearing to decide this issue, and now you want to, like, a week or 10 days before, try to amend, and not just like in a technical way. You're looking to amend massively, right? Something that the other side couldn't have possibly been prepared for, right? Like, and they shouldn't be expected to prepare for it in that time frame. It's fundamentally unfair. So, like, yeah, I mean, the Rule 11 stuff works for me too, but I would have stricken it down if not for that reason, for fundamental fairness. It's like, yeah, we already had this hearing on the clock. They already delayed it once because of you. They've already delayed it once because of you. You already asked for delay, and they were kind enough to say yes. And now you want to abuse that by basically at the last minute, like with 7 days left or 10 days left, you want to drop on them this Second Amended, which has all these new filings, right? And for a hearing that they can't possibly be expected to prepare for. It's like it goes against principles of fundamental fairness. So I could have stricken it down for that reason too. So okay. Andrew, I try to do things as timely as situations allow for. I have an editor. I have a process. It takes time to edit. It takes time to go through the process. Sometimes it takes a week or two for something to be posted. It's just the nature of things. So yeah. Did I read the Valo motion denying unsealing? I did not. I did not know. I didn't know that came down. I'll have to do that tomorrow. Yeah. I think Ty didn't know because of delays with COVID. I don't know about that. Yeah. Like sometimes videos come out late, because you got so much stuff. But we try to put stuff out. We got a whole huge backlog of stuff to be putting out. Do I think Vic is guilty or just not enough to sue? I don't have an opinion. I'm a legal analysis channel. I don't have enough. I don't have an opinion on any ultimate merits because we never got that far. There was enough to survive the TCPA in the Second Amended. There was enough to survive the TCPA and go to discovery and go to trial. So If the Tcpa, if the Second Amendment had been operative, there was enough to move to the next step forward. That's about as much as I'm willing to say on the record. But but based on the cases that exist, I agree with the trial court and I agree with the Court of Appeals. Maybe views on other cases suffer. I don't know if they do or not. They seem to still get a couple thousand views, which is, respectable. And it's content every day. We'll do a stream tomorrow on the Valo thing. How'd the case go? Vic lost and owes more money than he did before. How much more money is unclear, but probably another $100,000. So Vic has to write a big check. Vic has to write a big check. Would I ever have my mom or dad on a stream? Maybe, if I could think of a reason to do it. I wouldn't be opposed to it. Maybe not. I don't know if that's a good idea or not. I don't know if it's a good idea or not. Actually, now that you think about it, I mean, it's like because of exposing them to the public. I'm not sure if that's a good idea or not. I'll think about it. Anything else? I'm happy hanging out with you guys if you have questions or comments. A bad idea it might be. Have my mom on the phone for my passing the bar exam stream? That's okay. Blue Internet says, what was the one defamation case about the relations in the outhouse? That was Jerry Falwell. Jerry Falwell versus Hustler magazine. Famous case, U.S. Supreme Court. Where am I? I'm visiting my parents in their house in South Carolina. How's meeting Ty after learning about the case? I've never met Ty in person. Did I ever meet Andrew Yanko? I'm not sure. What do I think the most misunderstood case by the legal scholars in public? Oh, geez. Probably the McDonald's coffee burn case is still probably one of the most misunderstood cases. You're in Charlotte? That's cool. How am I doing? Doing all right. Doing all right. I'm happy. I'm glad I'm here with you guys. So, going to be a malpractice case? I couldn't speak to that. You'd have to prove that he'd ultimately win in order to win a malpractice case. You'd have to prove that Vic would have ultimately won. And That's difficult. You can show that you can show he would have gone the next step, but to show ultimate victory, it's tough. What's the limit for punitive damages in the Alex Jones case? We discussed that before. The limit for punitive damages is $750,000 per count. We calculated it at we calculated Alex Jones's total liability at $6.8 million when we did the math. I seem happier at my mom and dad's house. I'm happier overall. I'm also happier that my workouts are going well. That's been nice. Been logging those on Instagram. That's been validating. I love my mom and dad. They're great people. They really show me a lot of support. They really encourage me and validate me. Excuse me. They've been very supportive. They've been very supportive of me with the full-time YouTube thing. Been talking to them about my plans. They seem to think that they're good plans. With the Daybell trial and the Murdoch trial, get some good attention going. Should be awesome. Is there a final order yet in the Jones case? I don't know. I do have one brother. I'm sure my parents are over the moon proud of me. Well, maybe. They're good people. I'm ready to stream the Trump affidavit when it's released. Sure, of course. I'll be happy to. If we learn anything from the Trump affidavit, I'll be amazed. But I look forward to look forward to it. All right, I'm going to sign off for now. If you've been enjoying the stream, please remember to like, comment, subscribe, do all the YouTubey things. I'll be on tomorrow to discuss the Valo thing with the decision not to unseal. That's disappointing. I look forward to seeing the judge's reasoning on that. Andrew, I'm fine. Thank you. Although it is getting rather late in the evening, so I mean, you seem tired. You should have a nap, Andrew. It's 9:00 at night. It's getting a little late. I've been up all day, so it's fine. I'll sign off for now, man. I will talk to you later. Until later, my friends. Cheers and goodbye.